identify my client. It was at 5-something in the morning. There's no lights other than maybe some street lights. She has an extremely weak testimony in this matter. But for the grace of God, go us in this kind of case. And someone can just drive up and say that they actually saw someone with a gun and they get them charged with this. So I disagree with this experienced prosecutor who's handled thousands of these cases that there is enough evidence to bind my client over. Maybe if they had the gun, maybe if they had, or even identify my client as the driver of the car, but they don't even have that. So I'm asking the court to dismiss this.
Good.
And reviewing, the start of night, but in reviewing the case,
At Michigan's 34th District Court, Jeremy Taylor appeared before Judge Oakley for a preliminary examination on assault with a dangerous weapon and felony firearm charges. A woman reported a road rage incident on Interstate 275 where she claimed a gun was pointed at her. Trooper Johnson investigated, identified Taylor through license plate cameras, and conducted a traffic stop. During the interrogation that followed, the trooper said something to Taylor that would become a central issue at the preliminary examination. The defense attorney came prepared with serious questions, not just about the evidence itself, but about how that evidence was obtained.
state your name for us.
Elizabeth Worrell.
How do you spell your last name?
Worrell.
And Elizabeth as in Queen Elizabeth?
Yes.
Taking you back in time to April 23 of this year, 2025, at about 6 in the morning. Do you recall your whereabouts?
I was on my way to work on 275, coming up to my exit to get work.
Are you alone in the vehicle or do you have company?
No, I was like, so.
You started telling the judge about you were on I-275 North. Anything unusual happened to you when you were traveling on I-275 North?
I was on my way to work that morning and I noticed that there was a vehicle behind me. The vehicle was very close to the rear of my car. I had changed lanes a few different times. If I'm not mistaken, I changed lanes a total of 4 times.
Tell us about the weather. Was it light out or dark?
It was, it was typical, nighttime, right before the sun's coming up, it's about 5:30 in the morning.
Are you able to tell the judge the color of the other vehicle?
Yes.
What's the color?
It was like a dark gray, dark blue.
Are you able to inform the court the model of the vehicle?
Yeah, it was a Chevy Malibu. License plate was the first EJ1.
How do you know the license plate was showing EJ1?
Because as he was seating away from me, as I exited onto my exit to get off for work, he said past me at probably about 100 miles an hour. And I caught the first grade license plate and the description of the vehicle.
Anything more unusual happened while you traveled at 975 North?
When I noticed that vehicle behind me, like I said before, I had changed lanes. The vehicle followed me, and I want to say it was the 3rd time that I had changed lanes. The vehicle followed me again. I did brake check the vehicle behind me, which I know you're not supposed to do.
What happened after you brake checked?
He got to get closer. And so I had moved back into the middle lane, and he was again right behind me, even closer to the floor.
Anything happened after you changed into the middle lane?
Other than him following me, no, not until I had gotten up to closer to the exit I was getting off at.
Which exit is that?
The West Huron exit.
Anything unusual happened there near that exit?
Yeah, as after I had been followed back into the middle lane, I was just nervous at this point. So I waited until the last possible second, made sure that the lane next to me was clear, and I just booked it right off of the exit. And then that's when the vehicle pulled up next to me.
Anything happened when that vehicle pulled next to you?
I saw the outline of a handgun pointed at me.
How far were you from the person holding the handgun?
The vehicle had moved right next to me in that lane, so.
Can you give us an estimate on the distance? I'm going to walk towards you with the judge's permission. Can you stop me when I reach that distance?
Probably about right there.
Judge, may the record reflect about, I know I'm short, but about 7 feet. How certain or uncertain are you that a gun was pointed?
100% positive. I saw the outline of the handgun.
What were you thinking when the gun had been pointed at you?
That I was gonna be shot.
Well, what did you do, if anything, after the gun had been pointed at you?
I just got off right at that exit, and when I had looked over, the vehicle next to me had rolled the window down, and when that that gun at me. I did see the outline of the gun.
Was the gun pointed at you on one occasion or two different occasions?
Just once.
What do you do after the gun's pointed at you? Do you contact authorities in some way?
I had pulled
Sorry.
into,
You're all right.
I had pulled into work, contacted my wife and, let her know what happened. She told me that with.
Can't tell us what she said.
Right.
But anyway, you contacted
So-
your wife.
Yep, I contacted my wife. I ended up leaving work and, at the end of the road that I work off of, there was a New Boston police officer.
Did you have contact with the officer?
Yes, I pulled up next to the officer, explained what happened and asked what I do moving forward. And then that's when, we took my statement and this all began.
Are you able to identify the man with the gun? Why not?
It was too dark, I couldn't see the face. The only thing I could see was the outline.
Thank you, Brandon.
Mr. Weinberg, your witness.
Sorry.
Sure.
Sorry, that's Holster.
Sorry.
I'm sorry, what was your name?
Elizabeth Laura.
Elizabeth, my name is Scott White. I'm going to ask you a couple questions. If you don't understand them, let me know. I'll stop it when I'll rephrase it, okay? Sure, Sarah. Sir, can you identify that man at the table? You cannot identify my client, Mr. Jeremy Taylor, is that correct?
Objection's been asked today. It's
Is that correct? You can't.
been an objection asked.
Clarification.
So you have no idea whether or not Mr. Taylor was the man you're talking about that day, correct? And it was too dark to identify him. Is that correct? What kind of day was it?
5:30 roughly in the morning.
5:30 in the morning, so it was dark. And when did you claim that he actually pulled up next to you was the light in his vehicle on?
No, the lights on the, other side of the freeway, that's how I could see the backs of the gun, but I could not see
Okay,
his face.
okay.
Of what was gun is.
Well, did you ever touch that gun?
No.
And you can't identify anything other than the outline, correct? Right. Have you ever seen a gun close up before?
Yes.
Do you own it? Do you own a gun?
No, I do not.
Okay. You ever seen the outline of a handgun like this gun before?
To me, handguns for the most part.
You testified that this was a road rage type of situation, correct?
Yes.
And at some point, you slammed your brakes on in front of him while you were driving, isn't that correct?
Correct.
And that would precipitated this incident, correct? That morning, did you make a statement to the police?
Yes.
And again, did you tell them at that time that you could not identify the man or the person who allegedly pointed a gun at you?
Yes.
Okay. And did you ever tell the police that you heard this man say anything?
No.
So you can't identify his voice either, is that correct?
Correct.
You can't identify anything other than you saw the outline of what you think was a gun, correct?
Correct.
I go for this.
Any follow-up?
Thank you, Brandon. Go for the question.
Elizabeth Worrell just admitted she cannot identify the person who pointed the gun. She only saw an outline. So how is this case still moving forward? Under Michigan law, a preliminary examination requires two findings. First, that a felony actually occurred, and second, that there's probable cause to believe the defendant committed it. Worrell's testimony creates problems on both. She can't confirm a gun was actually pointed, only that she saw an outline of something she believed was a gun, and she cannot identify Taylor as the person holding it. But the state has something else, a partial license plate match, a gun found in his car, and Taylor's own statement that he was on that highway at that time. That's enough for probable cause. But is it enough to convict?
Ma'am, you can step down. Watch your step on my ramp.
Your Honor, we have one other witness. We'll call him, and that's our trooper, Trooper Jonathan Meyer.
Raise your right hand. Swear or affirm to tell the truth, the whole truth, and nothing but the truth today.
I do, sir.
Settle in. When you're ready, Mr. Campbell.
Thank you, Your Honor. Good morning, Trooper Meyer.
Morning.
Sir, how many years have you been with the Michigan State Police?
13.
So were you working on April 23 of 2020?
Yes.
Can you tell the judge where I-275 near South Huron Road, what municipalities in that area?
New Boston
In which county?
in Wayne County.
Sir, did you have an opportunity to speak to a woman named Elizabeth Worrell?
I did.
She's the woman who testified a few moments.
That's right.
Why did you speak to Ms. Worrell?
Miss Worrell Avenue, right there, just west of I-275.
Did you meet a man named Jeremy Taylor?
Yes.
If you saw Jeremy Taylor again, you recognize him?
Yeah.
Why did you speak to Mr. Taylor?
Mr. Taylor was my suspect, the registered owner of a vehicle matching the description given by the victim.
Well, you provided me a license plate, partial license plate number.
That's right.
What, do you remember what that is?
It was EJY with the first three.
Who provided that to you?
Miss Laurel.
In terms of that EJY 275 partial license plate description, did you attempt to determine the owner of the vehicle?
Yes.
How did you do that?
Using our license plate reader cameras in the area, I conducted a search using the criteria provided at partial plate along with a vague vehicle description, and was able to come up with two possible matches to that.
Ultimately, you narrow the field.
Yes, sir.
Who do you narrow the field to? Who's left? In terms of the EJY license,
Yeah.
have you determined who?
Yes, sir.
Plate
Yes, sir. So from those license plate reader camera photographs taken of that vehicle, I was able to retrieve that full license plate, run that license plate through our law enforcement information network.
And through a lien, did it identify anybody?
I did, yes.
Whom did it identify?
It was Mr. Taylor as the registered owner of that vehicle.
Ultimately, I'm gonna skip ahead for a moment. Did you at any point advise Mr. Taylor of his brand?
I did, yes.
How did that?
A traffic stop was conducted.
By who?
I did. And I pulled him over on 275 near Eureka. Spoke to him briefly, introduced myself, asked him if there were, or he declared to me rather, I didn't have to ask, he declared to me that there was a firearm in the vehicle, that he was a CPL holder. Shortly thereafter, I read him his Miranda rights, took him into custody.
So don't go any further.
Yes, sir.
Service the Miranda.
Yes,
Surprising of such rights, did you do so from your memory or from a form?
that's read to him from the form. I read that to him.
Can you estimate for Judge Oakley the number of times you've read Miranda rights to suspects?
I would say, fair estimate would be several hundred times.
Did you inquire as to whereabouts earlier in the day, like April 23, 2025, at about 6 in the morning?
Yes, I did.
What did he tell you his whereabouts?
He explained that he was traveling on northbound 275 on his way to work at approximately that time. And then he said something along the line of, oh, maybe that was this one. And then goes on to describe the victim's vehicle and somewhat of a low rage interaction between them.
Did he indicate to you any specific actions he claimed that the other woman took?
To my memory, that she brake checked him and flipped him off,
What is slipping off?
presenting her middle finger to him. A derogatory manner.
Did you specifically ask him whether he pointed a gun at another moment?
I did, yes.
What did he say?
He denied this.
Does he later give an explanation?
He does.
What does he say?
He said that it could have been that what she saw was him pointing his finger at her, and then later added that he may have had a coffee mug in his hand at the time he pointed this.
You indicated to the judge earlier in the direct examination, this saying you had a find it.
Yes, sir.
Did you find it on?
Yes,
Where you located gun?
in the center console between the driver's and passenger seat of the vehicle.
How far is that gun from the driver? Where the driver would have been seated?
Directly next to him, within arm's reach.
The information you would have been given about the vehicle, the claimant's vehicle, does that match or not match the vehicle you saw the defendant?
So it does.
How does it match?
The first three of the license plate match, and also she described the color and model of vehicle along with bumper stickers stretching from one tail light to the other across the
If
back.
those coincide or not coincide with the vehicle, you know.
Those all coincide.
What happened to the gun?
The gun was seized from the scene of a traffic stop and put into property at the Metro South Post.
When you recovered the gun from the center console, was it posted or unposted?
I do not recall.
Would your report refresh your memory?
Yes,
Do you have your report with you?
I do not.
Judge, do I have permission to approach the witness and have him review his report?
Sure.
What does your memory tell?
That in fact the firearm was in the center console unholstered.
Was the firearm loaded or unloaded?
It was loaded, magazine full.
If you investigated shootings in your career,
I have, yes.
tell the judge, and probably knows, a gun, which is more readily usable, a gun that is holstered or a gun that is unholstered?
Unholstered.
Thank you, Your Honor.
Mr. Weinberg.
Supervisor Scott, I heard when I asked you some questions, if you don't understand something, let me know. Yes, sir. So you were called onto the scene by other Police officer. Who else was first on the scene?
That would have been two we lost, and
So this wasn't a car, hers was pulled over by a speaker.
that's correct, yes.
And when you got to the scene, where was my client?
That was unknown to me at the time we were playing.
And at some point, well, then, back, did you pull my client over?
Yes.
You pulled him over.
Later that afternoon, yes, sir.
Yeah. So when you pulled him over because of this match and weight, correct?
That's correct, yeah.
And, did you first approach my client's car?
I did, yes.
It was he in the driver's seat?
He was.
And he, as you testified, first told you, right when you came out, that he had a CPO, correct?
That's right.
Yes, he was obligated to do.
That's right.
You didn't see him on the gun.
I did not see the gun at first contact.
And at no time did he provide you with the gun, correct?
He did not provide me, as in hand me the gun, no, sir.
Correct. So who actually ended up pulling the gun out of the car? Who found it?
To my recollection, I found it located.
Do you remember whether I searched and found the gun in here?
Yes. Now, I had two other troopers with me, so that's why I say to my recollection, I'm the one who pulled it out of the Senate Council.
And did you pull it out before or after you interviewed my client?
Prior to us removing the weapon from the vehicle.
But you had already interviewed him, correct? For so,
I had spoken to him, yes, that's right.
and you read his Miranda rules.
That's right.
At any point, if you take my client, put him in your vehicle, and start discussing this matter, interviewing him without reading his Miranda rules,
No, he had been read his parental rights prior to.
and you only read it once, correct?
That's right.
And when you read it to him, where were you?
Standing on the side of the freeway,
Where was he?
also standing there with me.
Outside of you.
That's right.
And when you first arrived at the scene, isn't it true that you took him out of his vehicle and had him sit in your squad, correct?
I don't recall at what time in the time or when in the time frame he sat in my vehicle, but he did sit in my vehicle. That's right.
And when he was in your vehicle, is that when you read his Miranda rights, or is it after?
I don't recall.
Could you recall getting a statement from him after you read his Miranda?
That's yes,
It was clear.
yes,
And do you recall your conversation when you spoke with him?
I do.
Do you recall the questions and the comments you made to him when you were interviewing him?
Not every comment. No, I'm sure not.
But you remember your conversation.
Yes.
And do you recall telling him the rendition of what was her name, the complainant?
Miss Laurel.
Ms. Morel, what she had told you, or what your understanding is of what the complaint was?
Yeah.
And that there was some type of pointing the gun at her, correct?
Right. Yes.
Isn't it true that you told him that he was involved in an accident with this woman? Do you recall that?
I don't recall.
Do you recall telling him that there was evidence to show that he actually did point the gun at her?
Yes.
From a video camera?
That's right.
Do you have any evidence of that?
No, sir.
So you lied to him about it.
You just heard a trooper admit he lied to Jeremy Taylor about video evidence that didn't exist. And the judge said he's allowed to lie. Here's why. Under the 1969 Supreme Court case Frazier versus Cupp, police can legally use deceptive tactics during interrogations. They can lie about fingerprints, DNA, witnesses, or video footage to get a confession. As long as the suspect was read their Miranda rights, it's not a constitutional violation. So why is the defense hammering this point? Not because the interrogation was illegal, but because it destroys the trooper's credibility. Taylor was lied to, and he still denied pointing a gun. He said maybe it was his finger or a coffee cup. The trooper lied, got no confession, and Taylor faces 6 years in prison anyway.
Yes, sir.
And is it your practice to lie?
Judge, he's allowed to lie.
Well, I'm asking you.
He can be Pinocchio, it doesn't matter. He can say whatever he wants.
I understand that, and I agree with you, but that doesn't mean Mr. Weinberg can't ask me questions about it.
Yeah.
So is it your practice to lie to a suspect during an investigation?
We object to that question. It doesn't matter what his practice is. It could have been the first time he lied, or he lies all the time. It's not relevant.
That would be an irrelevant. Go ahead. Relevance objection.
It's not only relevant, rather, it's also goes to his experience and his practice as a trooper. The prosecutor went into excruciating detail about how many types of stops he had, whether or not he's had gun types of investigations, whether or not he loaded, how he knows is it practical to have something on his hip if it's holstered or not. I'm just going by his practice in terms of interviewing witnesses.
You're stretching, but I'll allow it.
So is it your practice to lie to a suspect while you're doing an investigation?
It's not necessarily my practice, no, sir.
But you chose to do that in this.
Yes.
And you knew that, I can't remember it was on this floor,
That's right.
West Wall, or just for the record, is it, how do you spell?
Oh, W-O-R-R.
Warren. You
Replay
had
was-
told him and lied to him that there was evidence to show that he pointed the gun other than the smoke or around, saying that someone pointed a gun because she could not identify my client. Isn't that correct?
Well, we're checking the question, I'm still analyzing to understand.
Well, did you understand the truth?
I'm struggling to understand the question.
So let me rephrase it. Why did you lie to my client about the picture showing that picture that didn't exist, showing that he pointed a gun?
Judge and relevancy, it doesn't prove or disprove anything in the
Yeah,
contrary.
what's the relevance?
Well, that's why he was trying to get my client to admit something.
Well, I'll take judicial notice that it seems to have worked, if that helps.
Well, did he say that he agreed that he actually did point a gun?
No,
So he denied it.
that's right.
At any time, before you read his Miranda rights or after you read his Miranda rights, did he ever say that he pointed a gun?
He did not.
In fact, he did say that he might have pointed his finger or a cup. Isn't that correct?
That's right.
And did you hear Ms. Worrell's testimony today?
I did.
And you,
Judge, you can't comment on another witness's testimony.
I didn't ask him about it. I just asked him if he heard.
That's not relevant.
Besides Ms. Worrell saying she saw an outline of a gun, is there any evidence you collected showing that my client pointed a gun at Ms. Worrell?
No, sir.
Do you recall whether or not your squad car had a video in the set?
It does, yes.
And do you recall whether that recorded any of your conversation with my client in your vehicle?
Yes.
And you recall whether or not, had you reviewed that book?
It's been some time. I reviewed it either that day or that week.
But it's your sworn testimony that prior to interviewing my client in that vehicle or outside the vehicle or any time that day, that you read his Miranda rights, correct?
Yes, I let him swear.
I don't agree.
Mr. Kaplan, any redirect?
Can you demonstrate for the judge that did the defendant make any gesture when he described possibly pointing his finger at the moment?
He did, yes.
Can you show the judge, stand up and show the judge the gesture of the,
Yes. He said that he may have pointed his finger and did something like this.
So for the record, can we agree that the trooper has stood up and pointed his index finger with his thumb closed? An apt description? Go ahead.
nothing?
All right, and you recross. Trooper, you can step down. Watch your step on the ramp.
Your Honor, people are
Any defense witnesses? Argument?
running an interesting case before you, and we have a very good defense lawyer. Judge, in this case, the witness says a gun was pointed at her. Could she be mistaken? Yes, she could be mistaken. The question is the probable cause of the gun was pointed at. She seems certain, Judge. Despite a very effective cross-examination by Mr. Weinberg, she said that was a gun. I saw the outline of the gun. I've seen guns. That was a description. Now, in terms of who the culprit is, whoever did this, Judge, allegedly did it. It's driving a dark-colored Chevrolet Malibu with the first three digits of the license plate being EJ5. Now, think about that, Your Honor. Think of the coincidence if he's got the right guy. And he's somebody else driving a dark-colored Chevrolet Malibu in that area on I-275 North was involved in this. That license plate links him. Can I say to you, and you said this carefully, you're 100% sure? No, but think of the likelihood of this license plate featuring EJY and it being a dark-colored Chevrolet Malibu. And he had a gun in the car. And it wasn't holstered. Now, that's important. It means it's readily accessible. This was a road rage incident that spiraled out of control, and it's very unfortunate, but fortunately, nobody was injured. And the finger, once he thinks he's been nailed, oh yeah, they might have some video, they might have something where I'm pointing the gun, so, maybe it was my finger. That's not something you forget, Judge. It wasn't as though he had been interviewed weeks later. Yeah, maybe I pointed a finger. We would ask around to find the case, so where's Judge?
Mr. Weinberg?
Thank you, Judge. Well, I will go by a much better prosecutor than I may be as a defense attorney, but it can't just be, he could be mistaken. This man is charged with a 4-year felony and a mandatory 2-year felony firearm. They better have more than simply, she could be mistaken. She did not identify a gun. They had no pictures of a gun. They never identified any gun that she identified. They never had any evidence said, yes, that's the gun that was used, or this is what the gun looked like. It was an outline of a gun where she readily admitted it was too dark even to identify.
Determining whether it was probable cause to believe the crime occurred, then there's more than probable.
I don't see any way in hell of getting a conviction, but the probable cause burden has been met. I'm tempted to dismiss it just so we don't waste any more judicial resources, but that's not my role. I'm going to bind it over.
Thank you.
AOI is October 29.
At the close of the hearing, Judge Oakley sent the case to trial court, though he said from the bench he didn't see any way the prosecution could win. Mr. Taylor later took a plea deal for brandishing a firearm and was sentenced to 2 years of probation and 160 hours of community service. This case shows the gap between what police are legally allowed to do and what most people think is right. Trooper Meyer admitted he lied to Mr. Taylor during questioning, telling him there was video evidence when there wasn't. That might seem wrong, but it's completely legal. The law doesn't require police to be honest during interrogations. It only stops them from forcing confessions through threats or physical pressure. As long as the suspect agrees to talk on their own, officers can lie all they want, and courts rarely question it. What the law allows and what feels fair to everyday people don't always match up, and police interrogations are one place where you see that gap most clearly. Let us know if there is a case or courtroom interaction you would like us to explore in the comments below. Thank you for watching, and don't forget to like and subscribe.